So my name is Eleanor Marchetti. I'm the Deputy Chair of the Queensland Sentencing Advisory Council and I'm tonight's Chair. I would like to start by also acknowledging the traditional custodians of the lands upon which we're all situated, not just here but in terms of everyone who's watching this online, and pay my respects to elders past and present and extend that acknowledgement to any Aboriginal and Torres Strait Islander people who might be present listening tonight or present here tonight. As Margaret has pointed out, it is so important to take a cultural approach to any justice solutions. If we don't, we will continue to see, these atrocious figures. So thank you so much for coming tonight. It's wonderful to see such a huge turnout, although I can't really see everyone. But my job now is to introduce the outstanding panel speakers tonight, and what a fantastic panel we have to discuss current trends in sentencing of women and girls. So I will call out each panel person and as I call out their names they will come and sit on the stage. So I'll start with Thelma Schwartz. Thelma is the Principal Legal Officer at the Queensland Indigenous Family Violence Legal Service, an Aboriginal and Torres Strait Islander community-controlled organisation providing legal and non-legal support services to Aboriginal and Torres Strait Islander victims and survivors of family violence and sexual assault in Queensland. Thelma identifies as of Torres Strait Islander heritage alongside her German, Samoan and Papua New Guinean heritage. Thelma was a member of the Women's Safety and Justice Task Force. Second, I have Professor Thalia Anthony. Thalia has joined us today from the University of Technology, Sydney. Thalia's expertise is in the area of criminal justice and procedure and Aboriginal and Torres Strait Islander people and the law, with a particular specialisation in sentencing and Indigenous community justice mechanisms. Her work has been referred to widely in law reform and policy reports and debates. Next, I have Kylie Hillard. Kylie has been working in the legal profession since 2002 and is currently a barrister at the private bar in Queensland. Kylie works in a variety of criminal law areas, including industrial manslaughter, and has a strong interest in human rights and domestic violence advocacy. She is active on various committees within the legal profession with a focus on equal opportunities. Next, Debbie Kilroy. I don't know if Debbie needs a lot of introduction, but I am going to say a bit about Debbie. Debbie established and is the CEO, as we know, of Sisters Inside, a community organisation that advocates for the rights of women and girls in prison and provides a wide range of services. She also runs a law firm called Kilroy and Callaghan Lawyers. Debbie has lived experience of the criminal justice system and from the age of 13 spent over 2 decades in and out of women's and children's prisons. Debbie is an unapologetic abolitionist and she is widely recognised for her activism. And finally, but certainly not least, Natalie Lewis. Natalie was appointed Commissioner for the Queensland Family and Child Commission in May 2020. Natalie is a Gamilaroi woman, has a wealth of experience and knowledge from her distinguished over 20-year career in youth justice, child and family services and Aboriginal and Torres Strait Islander affairs. As Commissioner, Natalie drives change to better the safety, well-being and interests of children and young people, including those in the child protection system. Thank you to all of you on behalf of the Council for being here tonight to speak to us about this topic of sentencing women and girls. We have quite a bit of content to cover, and so I want to just let you know that so that we have time for questions at the end, hopefully. I'm hoping you'll keep your answers to any questions I ask to about 3 minutes. I will be keeping a bit of time, so I will have to interrupt if you go on a bit too long, and I do apologise in advance if I end up doing that. So I did have some other further, information about the reports and notes, but because Margaret covered it so well, I'm going to skip that and go straight to questions. And to do that, I'm going to sit down and join the rest of the panel members. So, as my first question to the panel, and this will be to the entire panel, but what do you think are the key drivers? And we heard a little bit from Margaret McMurdo, but behind the increase in female incarceration. So, look, I'll open it up if anybody wants to go first. Anyone brave enough?
Me.
Go, Debbie.
I'm brave because I can't see anybody.
Yeah, it's great, isn't it? You can just...
Before I speak, I do want to acknowledge the traditional owners of this land that we sit and those that are online. Here, Turrbal and Yagara people, I want to show my respects to elders past and present. We are on unceded stolen land, and I think we need to keep that in the forefronts of our mind, particularly in regards to what we're speaking about today, because when you walk into a women's prison or a prison where they hold girls, you will actually see the ongoing colonisation and genocide of the original invasion of this country that's ongoing. As I was sitting here listening to you, Margaret, and I'm sitting over there listening to you here, and you and John were reminiscing of your 5 decades, 50 years in the criminal justice system. I had my eyes closed listening to you, thinking about the 5 decades and nearly 50 years of my experience being caged and now representing women and advocating for women as a prison abolitionist, that we no longer use cages. And I think the piece that's missing here tonight that needs to be addressed is the racial gendered violence of policing. Because, and before that, about family policing, and we know that Aboriginal and Torres Strait Islander women are policed by what we call, or what the government calls, so-called child safety and child protection, and we know really any of us that have been involved or stand beside mothers who've had their babies removed from birth, particularly Aboriginal women, there's nothing safe happening and there's no protection happening. So we do need to address the racial gendered violence of policing, which also extends into those other carceral mechanisms that the state holds within the institutions.
Great. Does anybody want to add anything further to that? Yes, Thalia, you had your... No? Go for it.
I also want to acknowledge the traditional owners, and I'm from Sydney. I live on Gadigal. My family's from Cyprus, another colonised country, and I just want to say there are so many First Nations activists up on Meanjin that we really look up to in Sydney and to honour their struggles here. I just want to bring this back to sentencing, because we know there's been a really significant law and order shift across Australia, across the Western world in the last 30 to 50 years. And I think we can't pretend that courts have been immune to that shift. My research on sentencing over the decades has shown an increasing tendency to apply a deficit lens, to conceptualise things like deterrence, community protection, even rehabilitation as possible within the confines of prison. And I think this shift by the sentencing courts explains why women who are committing traffic offences, who are breaching orders, who are committing minor property offences, are sent to jail for short terms. That is a decision of the sentencing courts. And my research across Australia of sentencing indicated a more rehabilitative approach in the community before the 1990s. So I think that we need to critically analyse what is happening there and the decisions that are being made and how we try and shift the lens in the sentencing courts, not just judicial officers, also advocates, also the types of information that's brought, including the problematic, I would say, risk tools used in pre-sentence reports. So I absolutely think that we need to look at all aspects of the criminal justice system as responsible, but including in that is sentencing. And I just want to say one final thing, that in my research I've seen this deficit approach, this lens particularly taken to Aboriginal people, and I've spoken in New South Wales to almost 200 Aboriginal women in prison. This is not to say that there's not a problem. Just because it's a problem for Aboriginal women, it doesn't mean it works for non-Aboriginal women. I want to make that really clear. But having spoken to almost 200 Aboriginal women, what I heard over and over again was the stereotypes, the types of, problematising of Aboriginal women and their lives and their systems, relationships that did not conform to Western types of behaviours. And I think that also needs to be critically reflected on.
Thank you. So policing, sentencing, I might actually move over to Thelma on that note and get you to highlight and maybe discuss a little bit more about this sharp rise in Aboriginal and Torres Strait Islander women who are being sentenced for domestic and family violence breaches. And if you might just tell us what you think is behind this increase.
I think Debbie's rightfully flushed out that white elephant in the room in terms of racism and misogynistic approaches to policing. I'm unashamed in calling that out, and I full on support Debbie for using that platform and to speaking to it. And we're starting to see that, and people get really uncomfortable when I put together racism and misogynistic attitudes. But you're starting to see that with respect coming out through the Commission of Inquiry. Now, this is not me just pulling this fairy dust out of the air. It's there, it's happening. It is captured with respect in the 2 reports that I had the pleasure of being a part of a task force and speaking to women and girls who are journeying through this system. So why that's so important is that police are the gatekeepers to our criminal justice system. Now, if they are taking these approaches to interacting with women and girls, we are going to see them being charged, and you're going to see rates of overcharging. And what really concerns me and what we're seeing in the data, and I've got Natalie here who understands the data depths and what we're seeing more generally, is that when Aboriginal and Torres Strait Islander women come into contact with the criminal justice system, it's not only just them. We're talking about the flow-on effect to their family unit. We're seeing the impact of our children being brought in to the system. We're seeing them coming into contact with the child protection system. We're seeing them being removed. They then come into contact with the youth justice system. You have a plethora of reports on the so-called crossover children. I don't know how many times or how many more reports you need to say that there is overrepresentation, that this is negatively impacting Aboriginal and Torres Strait Islander people. But I have to admit that I'm getting sick and tired of it, given that there is substantive evidence to show, to justify reform, radical reform. And when people hear reform, we get uncomfortable. I hear people squishing around in their chairs, and it's like, oh, what does this mean? But you have to admit the system is not working, the system is failing, and it is now persecuting, with respect, Aboriginal and Torres Strait Islander people. And I note we have the National Partnership on Closing the Gap. We are not closing the gap. What is the point of having target 10 and 11 to see the reduction in the overrepresentation of Aboriginal men, women and children if we're not doing anything to reform our systems? We're then, the other white elephant, domestic and family violence and sexual violence. Now, I've been at a conference, a National Family Law Conference this week. Our Chief Justice of the Family Court called out the national shame of domestic and family violence. I echo that and I support it. It is a national shame, but more so, it is nationally appalling the rates of domestic and family violence and sexual violence that Aboriginal and Torres Strait Islander women and their children are subjected to. How much more as a civilised democratic society do we have to go through? And I'm so grateful that Margaret has brought in the statements of the Uluru Statement from the Heart, because this really echoes and resonates with me, because Aboriginal and Torres Strait Islander people were only seen through a criminal lens. We're viewed as criminals, we're sentenced as criminals. People that don't then look and unpack at why are we coming into contact with these systems? What is going on here? We like to give band-aid approaches. That's all we do, but we don't pull back and go, well, what's at the heart of this? What do we really need to address?
That's great. And I think it's so important to continue to highlight that, Thelma. So thank you so much for raising all those issues, and to both of you. Kylie, I might jump to you. From your experience as a barrister, can you tell us more about how, the circumstances that have been described here currently come into play when women and girls are being sentenced?
First of all, I'd like to acknowledge the traditional owners of the land on which we stand and welcome these fine women on the stage from their First Nations heritage. In respect of the sentencing process, most of my work is in the higher courts, the district court and up, and my experience is that it is incredibly difficult to get traction and resonance at times with the bench to put forward those gender issues. And I know, and we talk about statistics and we talk about First Nations statistics, they're often used to weaponise or to justify criminal behaviour, but they also aid in understanding some of the circumstances. When your client is a First Nations woman and she's a victim that is, has experienced domestic and family violence, she's something like 32 or 34 more times more likely to have been hospitalised as part of that domestic and family violence. She's something like 3 or 5 times more likely to have been raped or sexually assaulted. She is something like 2/3 times more likely to have been strangled or suffocated or had a head or a neck injury while she's pregnant. And she's about 1/3 times more likely to have a trunk injury while she's pregnant. And when you're representing a First Nations client on a sentence, first of all, it is very difficult to get that information from her because she has been beaten down her whole life. She has that intergenerational trauma, and it's very difficult to get that information from her and to give her a voice in that process. So when we're doing the sentences, we have to put this evidence before the court, and it's very hard to get that evidence and to get that in a coherent form, to get the bench to understand why she is there and why she's being charged. There's also needs to be a better understanding, perhaps, about how systems abuse has come into play and why she might be charged with a violent offence, for example, could be because the perpetrator against her has allowed a voice and is pushing the charges. So when we come to the sentence itself, typically we can put up the antecedents, we can put up the history, we can put up the information. But in my experience, when you have to go a lot further than that and get together the evidence, and it can be very difficult and very challenging to get that. And if I can give an example of a particular client that I had, she didn't happen to be a First Nations woman, but she got dragged into a trafficking, and she was involved in that because of her partner had committed really horrific domestic and family violence upon her. She had been strangled, she'd had a gun held to her head, she had other people threatened to be killed in front of her. And in that case, I was able to go through her phone, I was able to get photos of bruises off her phone, I was able to get text messages where he had abused her and called her names, I was able to get telephone intercepts as part of the prosecution case and to present all of that evidence. That was initially a contested sentence. It eventually resolved in an uncontested sentence, but I had to go through all of this effort and all of this work to get that evidence together, to present her voice in the court, to explain why she's there and why she shouldn't go to jail. And fortunately for her, she didn't go to jail. So it can be very hard to get the evidence you need because they are so traumatised, but it is also difficult to get the resonance that you need with the bench at times.
That's horrific to think about the obstacles that are placed for people appearing in front of court. And Natalie, we haven't yet really focused on girls. So our publication highlighted that the number of girls sentenced to detention had also tripled. What do you think are the drivers behind that figure or those statistics?
I just want to acknowledge that as a Gamilarayena, I'm a guest on country, and I've lived on the unceded lands of the Yagara and Turrbal people for 45 years. But as important as it is for me to acknowledge where I'm from, more importantly, and particularly in the work I do, I have to acknowledge the place I'm at and the obligation that carries. And I just want to say that, we talk about overrepresentation of Aboriginal and Torres Strait Islander children generally, but girls in the child protection system and in the youth justice system. We can't ignore the fact that, largely that's because the social and racial inequity and injustice that has continued unabated in every single system that interacts in the lives of Aboriginal and Torres Strait Islander people. And so this issue around care criminalisation, it is not a figment of the Aboriginal imagination. Our children and families come to the attention of Child Protective Services far more so than the rest of the population. And we've just released some data that demonstrated that in a particular area of Queensland, 74% of those investigations resulted in an unsubstantiated finding. But what that means is that rather than get access to support or recognition of and response to the vulnerability that families might be experiencing, what they've received in return is a child protection history and surveillance for however long it took to undertake the investigation. So I think that when we look at those rates of young women, when the rates are escalating in terms of children coming to the attention of child protection systems, and then that flow-on effect in terms of representation in youth justice systems, it is unsurprising. But the other thing I think is really important to acknowledge is that shift in the trajectory or those trends that you've reported on, I don't think it's a coincidence that sharp rise has coincided with some fairly regressive youth justice reforms in this state, 18 months ago. So while I'm certainly not letting people off the hook anymore with this thing about unintended consequences, we absolutely know the adverse impacts that are going to happen for Aboriginal and Torres Strait Islander children, and to continue and proceed anyway is irresponsible and it's cruel.
Thank you for that. Debbie, I'm going to come back to you, and it was going to be one of my original questions at the start, but remand. I want to hear your views on how that's impacting on, keeping women and girls in prisons and detention centres.
Sure. I think I just want to say one thing first. I think language is really important, and language is powerful, and language is impactful. And as long as we keep using the language of over-representation of Aboriginal and Torres Strait Islander women and girls, we're actually saying that some representation is okay. We need to use language of mass incarceration because they are criminalised and incarcerated by the state and by the agents of the state. And that's how we need to view it. The other thing is about the language of calling women and girls offenders. Those of us that have engaged find that language really offensive. And I don't care that government uses it in legislation, but I'm a human being, I have a name, and to call me an offender even today or an ex-offender means that at any time you may feel at risk that I'm going to offend against you when I'm not. And so language is powerful, and I encourage us all to actually think about the language that we use, particularly for the women who are criminalised and imprisoned that are before us, either as lawyers or support workers or judicial officers, because it is damaging. And women and girls can take on the over-responsibility of what's has happened to them from all forms of violence, sexual, domestic, physical and trauma, and blame themselves, as well as blaming themselves for recidivism, because recidivism is another word, language that's used that actually blames the individual. When the state does not provide safe public housing in its first instance, it does not address poverty. As Margaret said today, I think we're the 4th wealthiest country in the world and with the most resources, but we still, the rates of poverty and houselessness is growing and growing, and we're not providing that. Where people have more mental health issues and drug addictions because they're self-medicating with illegal drugs because they can't afford to go to a doctor or a specialist. So we need to think about that language. And so to blame people, girls and women, when they go into prison and then nothing happens there other than more trauma and abuse and be released and expect them to be a functioning, contributing member of our community is actually unfair because they come out worse than what they went in for. So we need to think about that language because it is highly damaging. And, you know, as someone who's been criminalised, what you do is punish yourself for decades and decades and believe that you're not worthy and that yous that have the professions and the jobs are actually more worthy than us. And that's actually not right. We're all humans and we all deserve respect and dignity. I think the issue of remand is huge. Natalie, you just spoke about, you know, the so-called reforms, which I think we've just got to stop talking about reforms, seriously. Reforms failed. It's like, seriously, this country was the reform agenda of England by bringing convicts here, right, us invaders. And, you know, here we are now. And what we've brought with that is a legal system that has impacted horrifically on First Nations people in this country. So we need to think about decarceration and uncaging people and work towards the abolition of the prison industrial complex and all its tentacles, because until we do that. And so remand is part of that. So remand is, you know, I see women going to court or girls going to court, and even though it's not part of the Bail Act, will be remanded in custody because they don't have an address. And police rely on all the time, prosecutors. And so then it's like, well, you go to prison because you don't have an address, or you go to prison because you have a mental health issue. You know, all these so-called risk factors. You know, and the biggest risk is that you won't show up because previously you've had breaches of bail conditions or failed to appear. But look, let's face it, seriously, I don't think we need to have any conditions on anyone for bail at all because, you know, those that are old enough, individuals that appear in front of magistrates' court, for example, for bail, are not the Christopher Skaifes of the world where they have billions of dollars and can flee the country. You know, I know a young Aboriginal woman that was given bail, and her bail conditions were to reside at her mother's, who lived beside a police station, and to report 3 times a week. At the same time, the police reported her to the family policing system, otherwise known as child safety, and removed her baby. And she was clearly distressed. So for 3 weeks, she actually, while she was fighting about her baby and have contact with her baby and to breastfeed her baby, she didn't walk next door to the police station to report. So she was charged with 9 breaches of her bail conditions and ended up in prison, remanded in custody for that. I think that is just outrageous that that's what we use a prison system for, to cage a young Aboriginal woman who's had her baby removed because she was criminalised and because she didn't then walk next door to report to the police who knew exactly where she was. They could have walked next door to her house, but they didn't. And this is the issue that we have, and no one questions that. We accept that. We accept the treadmill. And we've actually got to get off the treadmill and start supporting women and girls as human beings like all of us in this room with dignity and respect.
Thank you, Debbie. That actually, I'm going to go over to Thelma because that leads into a question I wanted to ask you about one of the task force reports, the second report, which recommended that there be amendments to Section 9 of the Penalties and Sentences Act so that, you know, a court considers hardships, you know, the hardship of any sentence. So things like, you know, that it would impose on a person, like taking into account their gender, sex, race, disability and parental status, which is something that, you know, Debbie was just discussing. So could you please tell us, Thelma, about these recommendations? And, of course, the reasons behind them are linked to what Debbie was talking about, but if you could just elaborate on that.
That's correct. I actually had to go back and dust off the old Penalties
really?
and Sentences Act. It's been a while. But no, I mean, I had revisited it obviously in the context of the task force work. We've heard and we've seen the data in this report that sentencing of women, and particularly Aboriginal and Torres Strait Islander women, is occurring within the magistrate's court. We're seeing that. So that you've got an evidentiary basis there. So when you look at the sentencing provisions contained in Section 9, subsection 2 of the Penalties and Sentences Act, it gives you a fairly lengthy list of sentencing guidelines and principles. And, having practiced in this area for a lengthy period of time, and I can understand the constraints and pressures, Recommendation 126 was trying to really bring to the forefront that when you are sentencing a woman, particularly an Aboriginal and Torres Strait Islander woman, there are a number of different circumstances as to why she's come before that court that have equal weight and value in the exercise of the sentencing power that should be taken into account to reach a sentence that reflects not only the principles of denunciation and punishment, but also, and equally important, rehabilitation. And I come back to when I went back in and dug around in there, you've got Section 9, subsection 2, subsection A, Roman numeral 1, and we're talking about why sentences should be imposed. And one of the key things is, right there in your Penalties and Sentences Act, that sentences of imprisonment should be imposed as a last resort. And secondly, in Roman numeral 2, a sentence that allows for an offender to stay in the community is preferable. So when you're linking these things in together, and our task force report spoke about additional community corrections orders. Now these types of orders are designed to assist getting at the core as to why people are coming into contact with the criminal justice system. What we're doing now is we are simply sentencing people to periods of imprisonment. They're going in. Now, we expect when they go into a period of imprisonment, you're going to get some rehabilitation in there. You're going to get some sort of program that's going to address the underlying causes of why you've come in. The stark reality is that is not happening. There are no culturally appropriate programs. There are no health-focused programs to really help people deal with the underlying causes of why they offend. And then we send them out. Off you go. Now, we expect that there will be ongoing support in relation to their connection with corrections to keep addressing those underlying causal effects. That is not happening. And you can see that if you go through and have a good old read of what we found in our task force report. It is a thorough examination of how the system is completely failing. We talk about remand. You go into remand, you're sitting there. Guess what? You have no access to programs. It's not available to you. And short periods of imprisonment are futile. You will not get access to programs. You go on a waiting list. If there are appropriate programs there, you wait. And by the time you may be eligible to access that, you can then come out. So what are we actually doing? What are we actually doing? And I think the second report, when you read it and you examine the system and you pull back your view and your lens of what needs to occur, I think with respect you will find that it is a system that is not working. It is not built and made for purpose now. It's not fit for purpose now. It's a system that came into this country when European settlers came. It hasn't shifted that much, and it's not affecting justice. What is justice? I get asked this all the time. Aren't we equal? Aren't we all, entitled to have the same access to justice and all of this? My response is no, we're not. We're not. And I've seeing what's going on in that system, the system is not working. It needs to be revamped, revitalised and made fit for purpose to actually assist people with what is driving them to come into contact. Get in there early because it's not working.
Thank you. You raised an important issue about the short sentences as well, and I might switch to Thalia here because you've been doing quite extensive research on taking into account community and cultural background of an individual when they're being sentenced and how these things might improve the sentencing, process and hopefully outcomes. And think about this issue of 3 to 6 month sentences when you answer this question. But how do you think submissions or reports could contribute to understanding systemic and cultural factors related to offending? And what impact do you think they might have?
Yeah, thanks, Eleanor. So, actually, along with Eleanor and Larissa Berend, we've been doing a project in conjunction with Victorian Aboriginal Legal Service, Five Bridges Community Justice Group up here. I'm also working with Deadly Connections in New South Wales to introduce what we call community justice reports for First Nations people. And the project arose because these organisations saw the limits in the information that the courts were receiving and saw that they tended to cast First Nations people within a risk framework that did not speak to them, as Debbie said, as a human being. It did not speak to their holistic life experience and even the experiences of their parents and grandparents and ongoing experiences of colonisation. So these reports, which we've introduced in both local and the county court in Victoria, these tell a story that is honouring their strengths, that looks at pathways that are not necessarily institutional. So there's a lot of talk about how we have diversion, and often it's through these institutional frameworks that are not really about self-determination. So for instance, when we did the research with the Aboriginal women in prison, the kinds of things they talked about was not going into a rehab facility, but going back to children, going back to family, going back to country, and doing work like setting up cooking classes on the Mish, or setting up a dog school, one of them said, or a dog centre for the other women who went to prison so they could send their dogs home. So they have these really innovative ideas that the system doesn't really hear or acknowledge. In the reports, they give some weight to these things to allow the First Nations people and the First Nations women to have a voice in the process and to be seen. Like Debbie, I've also been sentenced, and I know I absolutely felt alienated in that process, that nothing was with me, nothing was really about my life story. And so we try to bring this information to both tell that story, but also to give options that the court might not otherwise see, and to really push back on some of the racialised assumptions about First Nations people that tend to arise in the pre-sentence reports, but also are fuelled by, for instance, the court seeing the same people. And they tend to, for instance, with First Nations women, make assumptions about their parenting that are harmful because they don't fit into a certain Western mould. So it gives life to what their strengths are and how they contribute to community and fit into community, and why it's important that they're not sent to prison, which often severs those connections for a period.
Thank you, Thalia. Kylie, can you see how those sorts of reports or submissions, I guess, made in sentencing that include, discussion about the impact of systemic disadvantage, discrimination, intergenerational trauma? Can you see how that practically could impact on your work as a practitioner, or the work of others, of course, too?
They'd be invaluable to be able to have access to those sorts of reports routinely. At present, if you have a legal aid client, you need to get funding to get aid for a report, and you have to justify, the solicitors have to justify the purpose for getting the funding for the report. Then the second obstacle is getting a person who will actually do a legal aid report. And then third, finding someone who is culturally appropriate if they're from a COLD background, a culturally linguistically diverse background, and has the domestic and family violence knowledge to be able to elicit the evidence from them. So if you were able to have a properly equipped court service report like they have for some other jurisdictions, that would be quite invaluable. And I also think that when we're talking about those sorts of reports, I have often, for my clients, have gotten the detail from them, which takes a long time to get the detail because of the trauma, and sent that to the psychologists. And get your solicitor, or if they have a social worker who they work with, to get that detail to send it as well. And that's something that is quite helpful, as long as those kind of reports, if they're available, are properly resourced and equipped to get the information that they need.
Natalie, do you think that this could help with girls in the youth justice system? And would it be something that would, I guess, change the narrative to a more strengths-based approach rather than, looking at risk factors?
I think I struggle with the notion of tinkering with a system that's flawed to somehow make us believe that a couple of small tweaks is going to radically transform that experience for girls. And so I think that when we think about the things that would make a difference, better assessment, absolutely, more comprehensive, stuff that is devoid of a cultural bias, which I'm yet to come across such an assessment tool that's used in Queensland at least. And I think that if we understand those factors that are contributing to the offending. So whether it's around, just those experiences of vulnerability, about the invisibility of girls and their experience of trauma, the failure of systems around exclusion from education, for example. When we understand that they're the things that are driving the contact with the criminal justice system, rather than tinker with that system, I'd rather actually focus on the systems and their failures that are actually driving. I'm not sure if I'm explaining myself well, but
you are.
Yeah, but I just think that, we need to think about things like decriminalising pain-based behaviour. We know that for girls, that is what is presenting to the courts. And so, I know we talk about drug offences and things like that, but in the youth justice space, experiences of homelessness, placement instability and out-of-home care, and the notion of self-placement, those types of things are absolutely driving that contact with the statutory youth justice system. So, so I think that we have to understand those behaviours for what they are. They are pain-based behaviours, and we need to stop using detention as a sort of pitiful proxy for unmet welfare needs.
I think we really, need to be brave and think of like a completely different way of handling these situations. And Debbie, you and I were talking this is now not in your sister's inside hat, but at the meeting the other day about a trip you're doing soon to Hawaii. And you were explaining to me that there is a different approach over there. I'd love for you to quickly describe that.
Yeah. I suppose that when we talk about girls, I want to acknowledge Netari Mabo, who's here, who runs the Yanga program at Sisters Inside. So we're funded to support girls that are arrested and put in the watch house, to support them to get bail, and then support them in the community to comply with their bail conditions or youth justice orders or conditional bail programs, etc. And also go into the youth prison down here. It isn't funded for North Queensland, even though that we have lobbied for that, and which has been highly successful because Netari and all the staff of the Yanga team are Aboriginal women, and who Netari in particular is trained as an Aboriginal healer, and so we do a lot of that healing for the girls, and they're actually never criminalised and put back into the youth prison again once they go through our program, which is highly successful, which is really important, like what we were talking about, because one of the things, and I think probably the majority of people in this room listen to the ABC and probably listen to Phillip Adams, but before Phillip Adams had a podcast around the Hawaiian Youth Correctional Facility, I became aware that prison no longer has any girls. They've worked for a number of years, over a decade, where there's no girls in that prison any longer, and there's 16 boys. And what they did was, over a decade ago, the Children's Court judge and the administrator of that prison attended an event like this, where an academic from the University of Hawaii was speaking about trauma-informed practice and healing. And the judge and the administrator of the prison took that very seriously, but actually implemented those trauma-informed practices in a real way, not in a way that we do what we say happens here. Like yesterday, the family policing system didn't have trauma-informed practices. Today, they say they have. Can I tell you, they did nothing different. Like, seriously, nothing different. And so the question about, do we have trauma-informed courts? Well, hello. I don't know how that's happening. I'm sure we'll do the same thing yesterday as tomorrow. But anyway, it's all about marketing, right? But anyway, so I'm going to Hawaii, there's a symposium. So they have worked for over a decade and have had the courage and the political will, as well as the judicial will, and the will of those running the prison, as well as NGOs, that are Aboriginal NGOs, big ones in Hawaii, and to discuss about how they've got where they've got. And I think it's really important because Hawaii's in the US, right? Where they incarcerate the most people in the world. And here we have a youth prison with no girls, which is unheard of. So I'm going to go over there and speak to, I've already been speaking to the NGOs and the Vera Institute, who has been doing the research and the data over the last decade to drive the agenda. And basically what they're doing is addressing the social issues for the girls. So getting them safe housing, right? Getting them all the supports that they need, whether it's education, mental health, drug addiction, training, jobs, so that they're safe in the community and have those resources that we all have in this room, as privileged as we are, so that they're not incarcerated. And it's not rocket science, right? But I suppose the issue here is, look how many of us just in this room and those online that are making a wage on the backs of those that are criminalised and imprisoned. So, you know, it's an industry. And it net widens. And so what I get worried about these reports, and Margaret's gone now, the Task Force report, Productivity Commission report, all those recommendations, if they ever get implemented, and we know that they don't, because even the Ricky Dickey report with 339 recommendations still has the one here that about decriminalising or repealing public drunkenness. It still hasn't happened. You know, like that was 1991. So we need courage. We need to actually stop doing what we're doing because it just creates more, it net widens. And I know that's scary for people. You've got to, you know, we might have jobs in other ways, but that's okay. But at least all of us, or none of us, will be locked up, right? We've got to have a better community if people aren't criminalised and imprisoned. We must have a safer community. We've got to think of developing different modes of safety and security, not what we have now, which is the racial gendered violence of policing, courts and prison, and family policing, all those carceral strategies.
Maybe if we do that, we can all retire,
That'd
not
be
have
good.
jobs in other places. So just to end, before, oh, where's my watch? Here it is. I do want to hand over to the audience, but does anybody else, and I think that's an amazing initiative, and I'm keen to hear more when you get back, Debbie, but does anybody else have any other radical ideas? Like, you know, I mean, look, burn it down before we end. In terms of, you know, how we can reduce women, I know we've spoken a lot about, you know, the drivers of women and girls coming into contact with the criminal justice system, but do any of you have any other, you know, really out there ideas? I mean, we could, get a bulldozer and knock all the prisons down, I don't know.
I don't know if it's out there, I think maybe it's fair.
Yeah.
So we've been paying attention to some of the published judgments from Owen McGillery in Mount Isa. And what I found so interesting about that is the clarity with which the circumstances and the failure of systems that children are entitled to receive services from are so clearly sort of exposed. But the sadness in terms of at the end of those judgments is where you're seeing someone have to say, well, you've left me no choice. So for the failure of these systems and the inability of these services that receive, and I'm talking also about NGOs that receive a lot of funding as well, in being unable to provide, meet the basic needs of this child, that by virtue of that failure, the only option is to remand a child in custody. And I think that if there was perhaps the ability for magistrates such as Mr McGillery to order those responsible agencies and providers to demonstrate the active efforts that they've taken to meet the basic needs of a child before they're required to compensate for the failure of those services, I think that would be a really
Great
cool
idea.
bit of accountability to add into the system.
Yeah, yeah.
Can I add something?
Sure.
I was going to say one of the things that it's not particularly novel would be for the police to actually do their job and to protect women first, and don't under-police where appropriate and don't over-police where inappropriate, so that they actually perform. And picking up on the Mount Isa example, I'm involved with the Commission of Inquiry into domestic and family violence police responses, and there was a PCYC police officer who gave evidence up in Mount Isa just recently, and she's doing fantastic work with youth who are respondents on domestic and family violence orders, so kids as young as 13, First Nations as a respondent on a domestic and family violence order, and they're running these programs to try to disengage from that cycle and to try and get the alternative so that they're not being sentenced, because these kids are going to jail for breaches of a domestic or family violence order, and not necessarily going to jail for other offences that are to keep them alive. So it's just a crazy situation. But that's a positive example of when the police can actually do something outside of the usual box.
Thelma, Thalia? Any radical
I
idea?
think Debbie's probably really hit the nail here. We're talking about courage and we're talking about will. Courage and will. What is the point in Queensland of having a Human Rights Act that recognises the inherent dignity and worth of each single individual in this state? If you do not have then the courage and the will to change systems that are clearly not working, they are clearly not fit for purpose, they are clearly disproportionately impacting on a certain group of people. Come on now. Something's got to give. And I think, and I believe, I truly believe that there are people here who can see how broken this system is, how things are failing. I mean, what's that definition of madness, people? Doing the same thing over and over again and expecting a different result. Peel your eyelids open and have a look at it, and have the courage and will to effect change that brings about different results for people, brings around different impacts, especially for Aboriginal and Torres Strait Islander people. This is our communities as well. We have hopes and dreams and values that are as common and, connected to yours. We want the same things. And I think, and probably I'm a little bit more hopeful than I should be, I think that there will be change. I expect and I hope that those recommendations that my task force members and Margaret spoke to, that they are picked up and courageously implemented to see the change that we all need and we deserve in this state. That's what I hope. That's my radical plan. And, radical does not mean it's scary. Radical means that we are evolving and we are moving forward.
I think hope is very important. Yeah. Thalia, I thought you were waving to someone.
Final point, follow on from Thelma, just in terms of radical imaginings of a society where women are not imprisoned. I think we really have to build on some of the momentum around treaty making that's happening here and elsewhere across the country. And in the Northern Territory, for example, they are suggesting that in some communities they hand over jurisdiction, including criminal jurisdiction, to First Nations, to Aboriginal law holders, and among these law holders are women. And so we start thinking about First Nations women as those sovereign law holders, and stop thinking about the role of the state and its carceral systems in controlling these women, and in doing so we lose so much of that potential for First Nations women to lead. And I think we have to really try and flip the paradigm rather than just continue to tweak it.
I think there's always so much we can learn when we take a cultural, lens to something. So, yeah, definitely. So, I think this brings me to questions from the audience, but I can't see anyone. So, oh, that's better. Now I can see everyone. It was better when I couldn't see anyone. No. So we've got some microphones that are being handed around. If you want to just put up your hand, and if you have any questions, because everyone's gone shy. Was that a hand? No. Are there any questions from people? Oh, look, there's one at the back. Thank you.
I think possibly this question is for Debbie Kilroy. So maybe not a question, more of a statement. So in things that were discussed tonight, anecdotally, there's effectively a weaning down or a lack of rehabilitation programs for anyone on remand, women or children. So how is that best addressed? Who's accountable for that? Is it the correctional centres? Is it the government? How is it to be resourced? I understood through the work of Sisters Inside, which was fantastic in terms of, I know the women clients that I've had over the years, they're closely linked and benefit from the assistance that is offered through Sisters Inside. But outside of that, there once, for example, was job skill training. I had a client that once learnt how to be on her way to becoming a hairdresser. That program then was no longer available. So what once was like positive steps to skilling our clients for a better pathway when they were released, it's gone cold. So then on sentencing, just due to the lack of the waiting list, the lack of availability of courses, there's no recognition for, even though if your client, well, I believe there's no significant recognition where your clients are trying to get into courses to make something better for themselves. They can't get into it. So they're turning up to a sentence proceeding without the benefit of saying he or she hoped to get into this course. It's not as good as having done the course. So who becomes accountable? Where does that fit into the recommendations if we're still to have the correctional centres in some shape or form? So who becomes responsible for that? So how does that fit into all the recommendations?
Well, I think there's a number of recommendations, and we have a number of reports to fund those types of programs. But I mean, so it's up to the government to allocate the funding, or the individual ministers and their bureaucracies, but they're just not doing it because of the mass incarceration of women and girls, for example. We see then overcrowding, right? And so even to the point where the parole board now acknowledges that and knows that not everyone applying for parole when they're eligible will be able to do a program because it's not there. So it's not the prison system. I know people here have spoken about that the system's failing. I don't believe it's failing. It's working exactly how it's designed to work. Exactly, right? And that's where we've got to do some wedging. But I mean, it's interesting, just in the task force report, I think it's recommendations 111 and 113, it talks about bail programs for women. Now, we have run Supreme Court bail for women since the 2000s. We eventually got funded by Corrective Services about 5 years ago. And we appear as a friend of the court in the Supreme Court for Supreme Court bail applications. We support the women in their applications. Fundamentally, it's a self-rep application, but we'll find housing, find the services they need, do the affidavits, and then I will appear, usually as a friend of the court, not as a lawyer, because I'm not their lawyer in their substantive matters, to apply for Supreme Court bail. We've been 100% successful. So that's been funded for about 5 years. Caxton, where Dan, colleague Cusack, is on the board there of Caxton Legal Service, were funded for the men, for the same, they run it a bit different to us, but same. We were both, the bail programs were, for example, externally evaluated last year, a while ago anyway, and because Sisters Inside's bail program, Supreme Court bail program, is so successful, because we have got 100% women out when we apply for the bail, assist the women to apply for bail, has now been, will not be refunded at the end of this month because it's successful. Now, the 2 recommendations in the task force report talks about ongoing bail programs. Now, I know that Caxton's been doing some work behind the scenes. I have been talking internally. We haven't made it public. Well, I just did. I don't care. 2 weeks. 2 weeks. We have to let all our staff go. Like having a highly successful program that gets people out of prison. And sometimes Supreme Court justices say, oh my God, I don't even know why they're in prison. Do you know what I mean? Like, seriously. Because of the low-level types of offending, the survival offences. So that's a program that works. So then we have a, corrective services decides that it'll no longer be funded because it's too successful. Like, it's just mind-boggling, seriously. I don't know who's running this place. Like, I think you said, Tommy, it's like them doing the same thing over and over again. But I mean, I think that that's going to have a huge impact because now women know that it's not going to be ongoing funding, even though that we're going to continue it ourselves with no funding and try to do the best like we used to. But I mean, women are going to make applications themselves to the court, and I'm already getting called in by Supreme Court justices to please come and assist. They ask DPP rings me, I go there, and they go, can you find a rehab? I go back, I get staff that are engaged in other areas of support and service for women, and we have to add on. And so we're just working around the clock so that we actually get women out of prison.
It is appalling. I've been involved in research that has looked at both your work and Caxton's work, and it's mind-boggling why those 2 programs would be defunded. So yeah, it's 31st of terrible.
August, 2 weeks away, we're done.
Yeah, and that will have then an impact again on the topic we're talking about tonight.
Oh, absolutely. I raised the task force recommendations.
Yeah.
With corrective services, and they said, oh no, that's not up to us, that's up to that other department, the Attorney General. Yeah. So, it's a silo thinking. Yeah. This is not about women and girls. It really isn't, at the end of the day. Government, not interested.
I'll check with Victoria, who's somewhere at the back, who's meant to let us know if there's any questions from anyone online.
So we've got 3 questions. We've got, it's the voice of God here. The first question is from Panita, who's asking about the role of DV specialist judges in courts.
Would anyone like to tackle that? Kylie?
Particular issues.
Yes, Kylie's put up a hand to answer.
I think, there's domestic and family violence specialist courts, but that's limited to the Magistrates Court, but there are no specialist domestic and family violence district or Supreme or Court of Appeal. Right. And if there was that level of engagement, it would make a remarkable difference, because I wouldn't, for example, on sentence, have to step through so many hoops to satisfy the judge of the evidentiary basis that domestic and family violence does in fact exist. It shouldn't be contested on sentence, and that's why this woman is here being sentenced, because everything that's happened to her has caused this to come about. I think it would be wonderful to have that, and I would imagine that there would be quite a number of judges who would be quite willing to be engaged with that, because there's a lot of support from a number of different levels of the bench for that kind of work.
Thank you, Kylie, for tackling that one. Victoria, any other ones?
So we also have a question from Jones. Apologies if that's your last name. They're asking, wouldn't a start to a reduction of girls in detention be to raise the age of criminal responsibility to 14 in accordance with the UN recommendation? has this been considered?
It's a great question.
Go for it, Natalie.
Didn't we see the failure of the private members bill on that particular point this week? So let's have a look at it. It's out there. You've got Attorney Generals from different states and the Commonwealth engaging in this discussion around raising the age of criminal responsibility for young people, but still no action. And you know what? I'm really tired of the talk. I want to see action. How many reports do we need to do? And there are so many reports when we're looking at the brain development of young people and linking it to criminal responsibility. We are going to be, and I don't like being a pessimist, I don't, but I don't want to be back here in another 10 years and we're still debating this because it's nonsensical. These are things that should be occurring, and then hopefully this comes back to political will and courage and a recognition of some of these other things that don't belong with respect in the criminal justice system. They belong outside when we're looking at addressing some of these underlying social drivers, underlying issues.
So true. And you do wonder why people would think that children who are so young could really understand, you know, what they're doing and also be held responsible for things that are a product of many other factors in their lives, I'm sure. So, yeah.
I think one of the things, just on that point, one of the things that I always remember was a sentence I conducted for a young person no older than 10 years of age who was charged in Arakoon, the offence of stealing. Now, it wasn't the UTAG, the unauthorised taking of shop goods, and they charged that young person, 11, with stealing, and what he'd stolen from the store was a loaf of bread, peanut butter and some Vegemite. And there was no cautioning that was administered, nothing like that. And it came through into the courtroom. And when I spoke to him, that young person said to me, you know what, Auntie, I was hungry. And Mum and Dad, this was when there was no AMP in Arakoon, Mum and Dad, there's no money, it's all gone on the booze, and I got the little ones. Now, that was one of the first sentences I did in that Arakoon court, and that almost brought me to tears, that there was this young child, and there was another reason why this young person had done what they had done, and this was a basic human need that they were addressing. No cautioning, no UTAG, and, you know, the magistrate administered the caution from the bench. And then it was, what are the social services that now need to come in? I will always be stuck with that memory. And I am a proponent for raising that age. When I look at these things, and these are not uncommon stories that I've experienced in my criminal law practitioner life, why do we accept that?
Such a powerful story, Velma, and I think, you know, it's clearly stayed in your mind, and I think it's probably one that's going to stay in our mind too, because that's just a terrible, terrible, you know, situation and should never have happened. I might wrap this up because I think we've gone slightly over time, but not too much. So I think it's time for me to say my thank yous to everyone who's contributed to this event tonight. We're very grateful to Margaret McMurdo, our keynote speaker, and also to the members of the panel. Could you please give them a round of applause? Thank you so much for sharing your insights, your knowledge, but also your experiences. I hope everyone here, you know, has taken on board what you've said, and hopefully, I have hope. I think hope is good. So hopefully we might see some change.